And then I'm going to share the link in Twitter and on Discord. Where are we? Here. Let me tweet it as well. All right. And it is out. All right. Hello. How you doing?
Hey, I'm well, thanks. Yourself?
Doing well. Doing well. It's been a week, hasn't it? It's been a crazy couple of weeks, especially when it comes to IP. But before we dig into all that, I know who you are, but it'd be great if you could intro yourself to listeners, watchers, anyone tuning in. Yeah.
Of course. So first of all, thank you for having me here. It's great, to have this chat with you online. And then my name is Omri Bouton, and I'm a lawyer. I practice in the UK, and I specialize in, let's say, NFTs, but more so, crypto and the regulation that surrounds it, as well as intellectual property and commercial law that relates to it. So in the day-to-day, I deal with assist client with projects such as the launch of collections, interactive experiences that incorporate blockchain technology, and together with the team I work at Sheridan's, which is a media, entertainment, and sport firm. We really assist clients understanding the legal and regulatory implications of their project. So it's great to be here, especially after this week. As you said, there have been some important developments. I'm a punk as well. Of course, I'm a degen before for anything. Degen first, and then everything else follows. But so being a punk, of course, this week has been particularly important. But another thing that has been quite important, I think, is the introduction of KYC. And now, from since half an hour or so, we know better why that KYC might have been
do we? I haven't seen it.
Yeah, so but I mean, it's a rumor. I think I haven't had the chance to read it properly, but apparently, Bored Ape Yuga Lab wants to issue land. Want to sell, like there is going to be a land sale or something like that, but
like physical land.
No, I think metaverse based land.
Land. Interesting.
Yeah. So by way of NFTs.
Wow.
But it still comes as a surprise to many, the fact that KYC information is suddenly required to buy into a project. And reality of fact is, whilst the space is still unregulated to an extent, we knew that KYC was coming because, for example, in the UK, if you're issuing a token, a cryptographic asset, there are chances are that you have to comply with dedicated anti-money laundering frameworks.
Yeah.
And so it wasn't surprising. But what I think is interesting is the fact that Yuga Lab was the one to do it, because I think Yuga Lab was only one of the only ones to be able to afford to absorb the backlash that would result from that. Because imagine if you had a new project coming out to the market and requesting KYC.
It would be dead on arrival. Yeah,
absolutely, exactly. Yeah, and same goes for
Yeah, they got a lot of backlash. Even so, rightfully so. I think I'm wearing my ape hoodie, but I think if it was just the way they did it, they were just like, I understand why they did it, to build hype. Fuck it, KYC and a link to a K. But yeah, you can't do that in the crypto space and ask for people's everything. If they had come out and said, because of regulation, we want to do this. We want to sell land. We're trying to do something huge. We understand that you don't, all that kind of stuff. I think it would have softened the blow a lot. But
I agree. I think the communication. I agree with you. I think that communication could have been handled better. On their side. At the end of the day, we're all learning. I think we're both collectors and and I think project operating in the space. But I do agree with you. I think that the NFT community is very interesting because everyone is very savvy from a legal perspective without really understanding the law. And but I love the fact that the community is so interested in, for example, the grant of intellectual property rights, and something that we're going to discuss now, or like, for example, on the KYC, it's great the fact that, the community is very aware of it. The problem is sometimes there are misconceptions that can lead to, misunderstanding and damage to reputation on the part of the project, which is why I completely agree with you that, transparency and communication and education and awareness lies at the foundation of this cultural movement that is Web3, particularly now, where everything is being defined, and particularly for a project like Yuga Lab, you would expect, some higher level of trust. So I agree with you. I think also another interesting point, and just sometimes there are standard terms, is the fact that they dealt with personal information within the user-generated content. So it's almost like they're dealing with your personal information through a license that is normally used in respect of intellectual property rights. So it's a little bit interesting, but again, it's not. If you look at the real implications of that, I think if Yuga Lab delivers on the quality of product they will be delivering, and as we move forward, this will become standard for more and more projects. I think there are going to be benefits overall for the community, and they've done it so in partnership with Animoca, and Animoca is building this ecosystem with like several AAA kind of projects. So I think there might be a desire, I suspect, to have some form of interoperability at the regulatory level, and that is huge because we work with clients in the day-to-days that some of which also develop what people call play to earn, or at least like video games that incorporate some form of transferability of value. And there are several implications to that, and the KYC requirement and the fact that there would be a backlash going into the market requiring such information is often a big problem that projects have to deal with. And so if you're able, if Animoca is implementing this as an ecosystem, meaning that the players can maybe KYC once, and then they, like a Battle.net, an equivalent to Battle.net being able to access World of Warcraft and all of these other accounts to an extent, then I think that could be positive for the space. Perhaps it's hard to see it now, but if I look at 1-2 years from now, I think there are benefits to it.
Yeah, it's almost like it's a bit of a necessary evil, I think. Like we still exist in the real world. We still exist. We're all citizens of countries that have laws, basically. Even though that we live in this. Maybe in 50 years, 100 years, it'll be different landscape, and we'll have decentralized nation states. That would be wild, but who knows?
I was speaking about this actually with a client and a friend, about satellites and how does that work. The satellite is still launched from somewhere, and you have these several complex rules. You have complex rules revolving around, the establishing jurisdiction. What nation has jurisdiction? For example, you can look at international waters, but I'm very interested in outer space and, in the kind of like accumulation of resources from outer space or in outer space exploration. And when you start to try and understand what kind of law would apply, and, The Martian, also the movie with Matt Damon and the book, the writer for the book, also kind of touched upon it. It's not as straightforward as it may appear. And being stateless, I don't see it as something that can really happen right now because of how we're structured.
Not anytime soon. Maybe when we're actually on Mars.
Maybe.
All right, we have a bunch of great questions, and so I want to get to some of them. Bringing it back to the IP stuff. The very first question. I don't know if you saw them, but this one comes from Phalanx. If I turned my face into an NFT and sold it, would I still own the rights to my face?
Wow, that is not really well. It depends.
Yeah.
So if
we can ignore that.
I think it can be interesting. So it's when you say turning the face, does it mean that it's an artistic work over the face? Like, is it a painting? Is it an adaptation of it? Then you might have some IP in the form of copyright if it's sufficiently original. But if it's, for example, just a representation of your face, then I think the type of rights, there might be still an element of IP depending on how you capture it, but there is also the personality rights, and different jurisdiction handle it differently. So it's crazy. But I think, look, I mean, and we can go about this however you prefer, but I think it would be useful to just provide like a very short and general summary on IP, and particularly copyright, because a lot of time we do really speak about copyright.
That would be helpful.
And then we go from there, so that at least we have some like a sort of a framework on which to build.
For sure.
So I think one of the most important part about intellectual property is normally, on the first page of any IP book, and it's also the first part that everyone ignores, myself included, when I was studying. So it's, IP rights are negative rights, and that's quite important, because it just means that they don't positively entitle you to anything. For example, like, think about as a form of revenue, they don't really entitle you to do that. What they entitle you to do is to stop others from using what belongs to you, or like the form of property that is covered under intellectual property. So that means that simply having IP doesn't mean that you can make money or that you're entitled to anything. You can simply stop others. So you can see how litigation forms a core part of the right, because of course it revolves around having an exclusive right that belongs to you or to whoever is the IP owner, and then that right can be granted on a non-exclusive basis, on exclusive basis. So that means that you're authorizing someone else to use that particular piece of property in accordance to the rules that you create. And that's exactly what a license is. So a license sets out the rules on which you authorize somebody else to use that particular piece of property. Otherwise, what you can do, of course, you can also, because it's a right of property, you can sell that particular right to someone else. So that's quite important, because as you can see, stopping others, goes at the core of this particular set of rights. And I think this is important because you can see how scale is a problem when it comes to intellectual property. So IP is great, for as long as, for example, I own a particular piece of IP, you're using it without my authorization, and then I come to you, I sue you, or at least I threaten to sue you. It's easy to enforce one-to-one. But the moment you introduce scale in the equation, then it becomes difficult, because it's one thing to sue one person, it's another to sue 20 million people. So it's, it becomes harder. And, when we talk about internet, for example, even Web0, it's scale is at the core of the technology. So you can see that there is immediately a problem between, like, it's hard to reconcile intellectual property, or at least to enforce them at scale. So, and that's why, for example, in the music industry, that was a problem, because of course it's really hard to, to enforce a right like that, and to do something about it, And I think that's what's great about NFTs, because they allow a right holder to focus less. It doesn't mean that you stop focusing on it. Of course, it should be a priority, because intellectual property makes up about more than 80%. It's as an estimate of the overall market value of Western countries. So, like, it's very, very valuable, and that includes patent, copyright, all of that gig, let's say. But it's it's very valuable. So of course you should defend them. But at least what NFT provided the ability to do is to focus less on using IP to stop others from doing something, and building more, and building around your IP to provide value. So, like, building an economy around incentives rather than deterrence. And I think that's quite important, and it's quite of a shift in the way that you approach this. So if you look, for example, I think a good case study is Cath Simard, the Free Hawaii project. I don't know if you're familiar with it. Cath is a photographer, and she had this picture. She took this picture in Hawaii that went viral, and and by being viral, everyone was using it without permission, and she couldn't really do anything about it. And from what I understand, a few enforcement agencies try to work with her, to put the genie back in the bottle. But once it's out, it's really difficult to do. If not impossible, really. So what Kat did, she minted an NFT with that picture, and not only that. So to prove, I think, how useful NFTs can be. Upon purchase, one of the terms governing, the license of the copyright over the image was that it would become the IP would go in the public domain. So it's a CC0, meaning that there would be no copyright over the image. Everyone would be free to use it. And the picture was bought. I mean, the photo was bought by G Money, I think, for about $300,000. So
wow,
you can see how, and it was so cool. Interesting. I think it's an incredible use case to prove that provenance has value. That for the collector, the original authorship of a work means something, and it's almost like it proves the case for NFT, I think, because and actually what I loved about this whole Free Hawaii movement is that Cath and everyone around the promotion of this project, they were really encouraging at the time everyone to adopt the Free Hawaii as a background to their Twitter, to the PFP or to the banner. And I think it's very interesting. So that shows that project can focus more on either provenance or utility, which is of course token based and not IP based necessarily. So that's quite important in terms of, changing, like shifting mind about it. Now, in terms of when we look at intellectual property and the way that it is used in Web3, you normally have three main, buckets, let's say. Now, of course, each has its own shades, but in terms of, if you're the right holder and you create a project, right? So let's talk about PFP, for example, PFP and art. When you decide how to handle your intellectual property from the project side, you can normally decide, whether to centralize the intellectual property and retain all IP, effectively only granting the, NFT holders a right to access and the particular content or IP that is associated with your NFT for non-commercial purposes. That is similar to, going to a gallery, purchasing a painting, put it in your home, and that's it. You can't take the painting and suddenly start printing copies of it and commercialize it. The painter or the artist would have an issue with it.
Yeah.
So that's one of the options. And then the second option, and this type of formula is, I think, more suitable for art, fine art, or simply collectible items that don't necessarily, would require this type of commercial exploitation, which is more, I'd say, the second model, which is I call it community empowered branding, meaning that, and Bored Ape is the clear example here, meaning that you're creating a piece of IP, you're giving your community commercial rights to an extent, depending on how the license is drafted, and you are effectively building the brand together with the community, and you're incentivizing, the adoption of the intellectual property that you create. Importantly, when this community empowered branding normally is focused around copyright, meaning, for example, in the Bored Ape case, it's the actual ape that is associated with the NFT rather than the trademark. Now, the difference is, this is very, like, in general terms, copyright is to protect, let's say, the artistic work, and trademarks is to protect the actual brand, the logo, the logo that you have in your hoodie. That, for example, is property of Yuga Lab, and they want it because that represent, their trademark. They're like, when customers see that they associate it with Yuga Lab, and I think it's very important, for brand to retain ownership of their brand. I think this model, this community empowered branding model, is suitable for majority of brands that want to enter the space. I think it's a fantastic model. You can create new IP. There are some risks about it, of course, if someone uses a particular ape or a piece of IP that you've created in association with something that you're not very keen on, like, let's say, racist messages and all of that, like some racist imagery. You still have the ability, at least officially, to rescind the license. Now, it's, of course, if the token is in someone's wallet, unless the smart contract has a function. I think Pac had this function where it could recall a token back from someone's wallet, but you're limited in what you can really do, but at least you can take a stance in the terms governing the license, saying that, you don't have the right to use that particular piece of IP in association with anything that is immoral, and so on. So you can take a stance as a brand, at least. And you can request, for the takedown, for example, of the content if it gets really out of hand from the marketplace. And then the last one, it's CC0, or like IP that is in the public domain, and that means that effectively there are no rights reserved. So the original author or the owner of the IP releases the kind of exclusive nature, or at least like the negative side of the IP, and so everyone can use them. Now, this can be suitable, I think it's very suitable for meme culture, so to incentivize the adoption from the community, and facilitate the creation of derivative works, and but at the same time, it kind of reduces a little bit the appeal of purchasing an NFT, because unless there is some utility and unless someone cares about the provenance, then I could use an asset without necessarily owning it. So like Noon's DAO, I don't have to buy a Noon, like one of those character that they create. I can just use them, and it might be right for a certain project, but I don't think it's right for every project. And I think here, we mentioned two things that are often misunderstood within the space. One is the difference between having commercial right to a particular PFP or content that is associated with an NFT, and CC0. And the second one is derivative works, because the word derivative gets thrown around left, right, and center, but the reality, at least from a legal perspective, for a work to be a derivative work, it means that the work itself that incorporates an existing piece of IP is original enough to attract intellectual property, copyright protection in its own right. So, it's not enough, arguably, to just change the color of the background and say, yeah, that's a derivative. No, that's a copy, that's a reproduction. So, like, chances are it would be deemed as a copy. So, and I think that's important again, because, the reason
that's really interesting. Yeah. So then, all right. So how do you define what's original? Like, say something that's like, I'm sure this is a project, but doodle apes. So someone that takes the apes and the doodles and creates something original, combining elements of both. Is that original enough, or is that just copying two projects instead of one?
It's a good question, and it would be a question of fact, and it would depend a lot on how it is argued in court, if it ever gets in court. There was the test change, and especially, I'm talking about the UK, but the test change across the ages. Let's say, in the past it was more of a sweat of the brow, meaning it was an effort-based test, whereas now it seems to be moving more toward a, injecting the mind of the author into the work. So it's not very, to be honest, the threshold for originality is not outstanding. It's kept low, because what happens is the justification for it is that you don't want to get into criticizing what is worth and what is not of protection. You don't want to get into that as a law, as a legal framework. You want to be able to be as agnostic as possible, because art is in the eyes of the beholder, and some people can find something completely useless, and other people can treasure it as a form of, as a cultural movement. So if you start criticizing the quality of the work, the problem, and infer originality on the basis of the quality of the work, that becomes a very subjective view, and you don't want that. You want to keep it as objective as possible. So it's more about the approach of the author to the work than necessarily the inherent quality artistically of the work itself. What you don't want to do is to have a copy. Also, another thing, for a derivative work to have intellectual to get the copyright protection, it needs, of course, to be made to be created lawfully, meaning that if it incorporates an existing piece of IP, you would need the authorization to create a derivative from the person that holds the right, because one of the rights that you get as an intellectual property owner is the right to make adaptations of the work, hence the derivative. So
it's also interesting, and it's so crazy considering. I'm sure the project's out there, but I'm gonna get to some of these questions. I think this is a good one, a proper good one to start on, aside from the other one. Mushroom asks, if a project hasn't explicitly declared what the commercial licensing structure is, what is assumed to be the default?
The default is that the copyright and the IP stays with the project. So the default is simply by design, because the NFT has metadata that would likely point you toward the content. We assume that you have at least the right to access it for non-commercial purposes, because it would be, completely logical to sell an item that, automatically opens an image, and, you being infringing on someone's right.
Yeah.
So I'd say that as a minimum, you have the right, to access the particular content that is associated with your NFT for non-commercial purposes. So that would be the minimis, let's say, a right that you have, and which is quite limited. But again, like, if you think about buying art, that's kind of what you get normally, right? When you purchase a painting or so.
That's great. All right, we have another question. This is from the Lawyer 25. What are some examples of what are some examples of NFT or intellectual property use you've seen in the space thus far, such as Jenkins and Kiki? What characteristics in a project or specific NFT do you believe make it amenable to successful future IP use?
I'm not sure I understand the question, but
I'm not sure I do either.
One of the characters is Jenkins the Valet. One of the projects, I guess, by Jenkins, they refer to Jenkins the Valet. It's probably, I think what's interesting about that platform is that it gives, and I think we will see more and more of these type of platforms that allow holders of NFTs that provide commercial right with an avenue to exploit the commercial right. Because something that Spotify said at some point in the past, and I completely agree with it, is that everyone wants commercial rights to their PFP, but it's not easy to exploit commercially a piece of IP or building, IP within a particular asset. Not many succeed in that, and it's difficult. It takes time and effort to do that. So yeah, I'm not sure I understand exactly the question. I guess community, like if it's about how can you create IP that is more likely to be adopted and becomes valuable in time. I don't think it's only in terms of IP. Of course, there is an element of IP of appeal to the collector, and so how it looks, so the quality of the work. I guess another element could be the play on culture. Although there are so many ape projects right now, that, it has been that avenue exhausted a little bit.
That's been done.
The community, of course, incentivizing the formation of the community, and I think. Although it's not strictly IP related, I think it's interesting as a conversation. There is this trend now in the space, and I see it with clients. They come to us and they immediately want to offer staking and all of the rest. And I'm not saying that that's a bad thing per se, but the problem is that there is an increasing pressure on the part of projects almost to buy their community. It's to provide so much financial value that effectively. Yeah. Getting into the project is a no-brainer, but I think is that the type of community that you want? Because you're effectively creating a financial product, with the UX of cute character, cute PFP character, and I think a community like that is very volatile because the moment the economy doesn't work, you have no one left. Whereas especially I don't know if there is anyone that listens coming from the traditional creative industries, if you're in music, film, and TV. Video games, really anything like literature, if you're part of a subculture and you want to use NFTs as a way to further that subcultures within this new space, I think you should focus around injecting the NFT with as much value as possible for your particular community. And that doesn't mean financial value, monetary value. It can mean, it will be very specific to the community that you have. Because at the end of the day, NFTs are infrastructure. They're not product, services, or experiences. You build that on top. So I think that's very important. Yeah, I just want to mention this part of it.
Yeah. Very, very, very interesting. Girl just want to have funds says, what is normally forgotten? It's a great name. What is normally forgotten about or ignored at the beginning of a project that have become issues later on?
Okay, so a few things. First of all, the financial services and anti-money laundering risk. Number one.
What is that really? Like, what is the risk?
Yeah, of course. I'm going. Well, there are. So let's say first I'll list them, and then we go into each of them because I think they have equal importance, really. One, actually, to keep it in line with this talk, is intellectual property, and I'll explain why. Second one is financial services and anti-money laundering risk. Third one, potentially, depending if there is an interactive experience, gambling. Fourth one is, I would say, taxation, but not from the point of view of I don't have to pay taxes, is understanding what are the taxable events that can make you liable and on the basis of what, swing in value. So it can be very complex. It can vary based on jurisdiction. I'm not a tax attorney. Every time someone comes to ask me for a tax, it's the quickest reference I make. just like with a mirror. So just to be clear, nothing I say is legal advice. Please take this as more. I should have said that at the beginning. It's more as educational, so that at least you are aware of the areas of risk and you can instruct your lawyer accordingly. So starting from intellectual property, and that doesn't necessarily apply only to NFTs. It applies really to any business endeavor. At the beginning, of a startup or any commercial endeavor, founders have a lot to think about. They have to think about developing the product, the service, finding the customer, marketing, partnering. One of the things that get left out is things that are not immediately obvious. For example, intellectual property, because you're dealing with something that is abstract. It's intangible. It's intangible value. So it's not like an office that you need to rent. It's harder. It's harder to think about these things on the outset, but they can come back. They can bite you back in the future. So it's important, for example, if you're commissioning the creation of any piece of content or any piece of software that is paramount to your operation, it's important that you make sure you centralize the intellectual property and pay properly for it. I'm not trying to encourage you to be a magnet, and being unfair commercially, but you want to make sure that you are the holder of all of the intellectual property that is relevant to your project. Because, for example, if you, on the other end, are dismissive about this particular point, you go, transact, come someone that want to invest, they run due diligence, they understand that you don't have the intellectual property, trust me, they will probably walk away from you. And, you see deals that fall because of that. And, it's really sad, because I think there is a lot of value in what they've created, a lot of effort. And because of formalities, there is that risk of not being able to exit as intended. So that's one. Second, financial services and anti-money laundering. I understand why that can be misunderstood, especially in the NFT space, especially if you're a creative and you just want to use NFTs as an avenue for your creative expression. But you need to understand that NFTs at the core are cryptographic assets that are, contain metadata that points to a certain content. And cryptographic assets are regulated. Please don't think that they are not regulated, because they are already regulated normally under, traditional financial services if the particular NFT, has characteristic that effectively makes it equivalent, let's say, to a security. This is a case that everyone knows about, but they can also, they can represent different types of security, sharing companies. They can look like, for example, units in collective investment schemes. So, and it's really hard, like there isn't really a blanket approach that you can adopt. You need to look at the token, how it behaves, what are the rights that are attached to it, and then you reverse engineer and you're trying to understand the kind of legal and regulatory implications of that. So that's really important. And anti-money laundering, which is kind of related to financial services, is again, what duties apply to you before you sell NFTs to the to anyone, because you might be subject to certain requirements. For example, to running KYC on your customer, or to registering, for example, with the financial services regulator. So it depends by the jurisdiction. Every state goes different about it, I'd say, and there isn't really much harmonization. The Financial Action Task Force releases, consideration and recommendation, especially on anti-money laundering. And that is considered, the kind of approach that likely most jurisdiction will follow. But again, you really need to instruct a lawyer and and choose the right lawyer, because NFTs are very appealing to commercial and intellectual property lawyer. And, they might be great at that side of the law, but they might, be less aware of financial services regulation and anti-money laundering. Now I think there is more awareness that is building in this particular space, also because of news in relation to SEC intervention in certain cases, like especially last week with respect to fractionalization and all that. But make sure that you consider, don't be dismissive about it. And then finally, I'd say gambling, because when you look at loot boxes, and again, gambling is not really harmonized. Every state and every jurisdiction has its own rules, but it's a risk, because if you have an interactive experience, at least, for example, I can give you the example in the UK. Normally, the reason why traditional video games may not fall within gambling, and there have been frictions, like also in respect to traditional gaming, is because normally you're not allowed to extract value from the title, from the game. And loot boxes have been argued, like there has been a lot of backlash. In some jurisdictions, I think, have regulated loot boxes as gambling, but I know also that, like, for example, in the UK, there was a kind of an opinion of the Gambling Commission saying that because you can't, for as long as you cannot extract value, then it should be okay. Although it's not really, it's not the practice that is most appreciated by the Commission. But when it comes to NFT, these are transferable. The transferability of NFTs lies at the core of, or crypto asset lies at the core of the technology. And so, of course, you lose that element, which means that your particular interactive experience could amount to gambling, and you need to consider these things. So, look, at the end of the day, we're looking at the technological convergence. Now we have infrastructure with an economy embedded into it, which can also execute. So you have, of course, all of the smart contracts, meaning that you can gamify certain aspects, you can transfer rights by way. So as technology converges, and as different aspects and industry converge, so do area of law. And so you need to consider these. I know that it's a lot to consider, but I think that if you have a good project, the economical, the kind of cost that you might incur from a legal and regulatory perspective at the outset is justified by the potential gain that you get later. If you're a successful project, it can be very successful. Another option you have is because, you don't necessarily have to implement all of these functions yourself. You can potentially partner with entities that are either authorized or licensed to carry out certain activities or that are more experienced. It's really hard to give tips on what one can do. But I really think, just the best advice I can give is just pick up the phone and call a lawyer. They're not going to charge you for the first, 10, 15 minutes of a call. And at least you get an idea, and don't be dismissive about it, because it can really, you don't want to put yourself in a position where then, you can't go back in time. So I think it's useful to consider and be aware of this.
Yeah, I've spoken to so many lawyers and accountants over the last 6 months. And honestly, I spoke to probably 10 different people for 15 to 45 minutes each before paying anything. And it's like you get so many different perspectives and insights and opinions till you find someone that gets it. And then they charge you through the teeth. But it's great. Yeah.
And it's
necessary.
That's and it's, the point is, it's not unregulated. There is a lack of guidance on many aspects. And that's the problem. That's where the interpretation comes in. And that's where, also as a lawyer, the best you can do is, get as technical as possible, try to understand as well as possible, the kind of approach that a particular regulator would take in respect for the financial services side and anti-money laundering side, and gambling as well. The type of view that they might take on something, but it's not a great position to be in, because you can give little certainty to client, but at the same time, when you're dealing with regulation, normally it comes down to, I think, risks. It's hard to define a black and white, particularly in an industry like this one. So be careful, because the risk might not be obvious. So as a project, please be careful. Please don't be dismissive of any aspect.
No, I think that's great. You've given, hopefully, people a lot to think about if they're launching a project, just to be aware of these things so they can ask lawyers these types of questions.
Then, the lawyer can't force you down the path. We can only tell you, look, this is the risk, but we advise you against it. Then, it's
you can do whatever you want.
It's very difficult. Look, the reward is huge to be in this industry. So, it's don't be dismissive. I think, professionality, approaching project with a professional take, building an infrastructure around yourself that is capable of supporting the growth of the project, and including service providers like lawyer, accountants, having the right bank that can assist you, having I think it's really important. I think regardless of NFTs and crypto, the main difference that I've seen between one of the main differences that I've seen between successful entrepreneurs and people that are wealthy and people that maybe had the commercial success but weren't able to sustain it, one of the differences is to build to invest in infrastructure around themselves. And I've really seen how important that is. And I think yourself, you're doing it as well.
Basically, I've spoken to lawyers and accountants, and my thinking is, I know it's going to cost, whatever it costs, but I want to be able to sleep at night. Is the end of it. That's my litmus test.
I'm not talking only about lawyer and accountant. I'm saying also, like, for example, developers and talent, which is, try to build
have the best team,
competent framework around yourself, community manager, all of that, going back to what makes a successful project. All of these components are equally important, in my opinion,
100%. It's the team. Like, if I'm looking at a project to evaluate whether I want to buy into it, be part of it, I always say, look at the team, look at the founder, look at the community managers, the developers, the artists, and that's what makes a project.
I agree.
All right, so we have a question from Kit777. It might be too specific, but she's interested in how, if you're familiar with the situation between Artifact and Nike, and who sort of like their licensing, who owns the IP there when Nike acquired Artifact, what happened to, like, what should NFT collectors be aware of, sort of like in that situation, or like
Yeah. So first of all, the specifics around the acquisition are going to be confidential, so I have no access to them. And even if I had, I wouldn't be able to speak. I don't.
Right.
But I don't want to try and claim, no stuff.
Yeah.
I don't work with them, unfortunately. Love Artifact, massive fan.
Yeah.
And collector. But so in terms of Artifact, the type of terms that apply, there are 2 licenses, and there are, if you go on OpenSea, for example, they're in the description. If it's a project with incorporating a Murakami trait, then you have no commercial rights, and it is treated as art. And I don't know, my guess is that it's because it's done with Murakami. And if it's on the other end, a clone that is free of Murakami traits, I believe you have up to £1 million of you have commercial rights up to a value of £1 million. So if Nike acquired the entirety, from what I understand, that's what happened, of Artifact, then well, the IP would belong to Artifact, and Nike would be a parent company that owns Artifact, so by reflection,
right,
they'd be able to. In terms of how, I think that, it's in terms of these kind of caps on there is the 100K on the Me Beats and like the 1 million Artifact. I think it's hard sometimes to understand, to enforce that, but my assumption is that it is placed there, not so that if you make 1,000,001, then you're screwed. That's it. You have the lawyers.
Yeah.
It's more if you take 5 clones, because I think they want to release the rigged version of the clones in 3D. If a game studio decides to buy 10 of them and makes a landslide commercial success, then of course that clause would force you to involve them in the process and seek a separate license, which I don't think is a bad thing, because if they're the original creator of Clone X, they might create custom assets for you and your game. So I think Web3 is novel enough so that there is really enough upside for everyone, and collaboration is really at the core of it, in my opinion.
Yeah, no, 100%. All right, we have another question from Mushroom. Do you think that the response by platforms such as OpenSea to claims of IP infringement has been adequate? And if not, what would you recommend?
That is a difficult question, because you need to be able to see both sides. The whole DMCA framework is complex. To be honest, I'd rather not take this question. Not because I've been involved in DMCA or not. It's just because I don't want to be dismissive about it. There are lots of considerations that go into it. It's a difficult one. But when it comes to distributed, file storage system, aside from the blockchain, normally the standard right now, I would say, is to store content that is associated with NFTs in IPFS or Airwave. So it becomes really hard to take down, if not impossible, to take down the content. So taking down from the marketplace might be the only option that right holders have. And I'm not saying that it has been handled well or not. We all know the criticism toward OpenSea. It's imperfect. I think OpenSea, for example, and if you're listening, please implement something like this. I think that there is a need for sellers to be able to flag if a particular PFP has been commercially used in or if there is a license. I think that would be very useful on the side of the seller just to make a purchasing decision. I think that but again, it's a new space. We're trying to learn how everything happens.
On that note, I mean, we had a question come in as well that might be related. It says, what happens if you build a brand on, let's say, your Bored Ape and later sell the ape? Can the new holder then go against your brand because you no longer have the rights? Does it only affect new content you produce, or also previous content produced while you were the holder?
It's really difficult, and again, it's not something that I would want to answer specifically on the call. It really depends what you mean by building the brand. Like, have you licensed, for example, have you granted commercial rights over your ape to someone else to build the product? If yes, what kind of product? Normally, there is this buyer beware sort of situation, but at the same time, the person seeking the license would probably put in the license things such as, you grant me the right perpetually, and it's for you to that's your deal. So it's a difficult one, but it's hard because normally you would run due diligence, but in a way here there is no agreement. Like I mean, there is an agreement. I'm not saying that it's not enforceable, the sale, but it's not like a traditional sale of IP where you run due diligence. You understand if a title is free of encumbrance, the buyer gives you, some warranties, meaning that they state whether there is IP or not, and then you have a claim against it. It's far more complex.
All right, we have a question from Praetor. How can buyers ensure that the IP rights represented to them at mint stay the same in the future? What's the legal process if someone wanted to change them in the future, and would buyers have any recourse if that process wasn't followed?
It depends by the terms. Like, project will likely provide the license in the form of terms on the platform, on the website, almost like EULAs and user licensing agreement. When you buy a video game and you say I agree, and that kind of governs user generated content and so on and so forth. So it really depends by that, and they would likely retain the right, to the ability to change it, or at least have it conditional on certain. So for example, I think Yuga Labs is like a board is like, for as long as you abide by these terms, then we're granting you a license.
Okay. Next question is slightly related. I think I actually mentioned on one of my recent podcasts, which this situation was posed to me by someone else. But anyway, what happens when someone takes a BAYC branded shotgun and kills people? Like, from a legal perspective, are there risks always to mitigate risks associated with granting IP rights to the owners?
So, like, what's wrong with the Zen Academy community?
Hey, this came from me. Actually, this came from John. I was having a YouTube chat with John Rogers, he was the ex head of franchising at Disney and franchise development at Disney, and he's thought a lot about brands and stuff. And so he was saying something along the lines of, Bored Apes have given out full commercial rights, so people can literally do whatever, right? They can. It's not like really a restricted license.
Not really, because like if you said a branded if it's with the trademark, then you don't have commercial right to the trademark. You only have the commercial right to. Okay, if it's an ape branded, then that's we go back to what we said. Yeah, you would insert for example things saying when we prepare licenses, we include wording saying you wouldn't want basically unauthorized uses. Like you shall not use this piece of content in association with any immoral act or all of that. But beside that, first of all, if someone has a shotgun and they're shooting, they will go to jail, and like that would be criminal liability. You could try to claim some tarnishment on your brand, but I doubt they will have any money to pay you. So also that.
Well, I guess maybe what if someone's they say I'm going to create a company selling
shotgun branded
with
shotgun
my ape as it, then you can come up with a company in it.
Maybe. I guess that it depends by the terms of the license. If the license doesn't forbid you from doing that, then it can also be a legitimate use. I'm not pro weapons or anything. I'm
self-defense, all that.
I see a metal cup and I think about Chronicles of Riddick and how that dangerous that is. So guns are not for me, but for example, I guess if you have a right to hold a gun and you're a gun company, you could do. I'm not sure. It depends by the terms of the license. Again, because the person that holds intellectual property sets the rule on the use of the intellectual property. So it all goes back to then. All the question relating to can you do that, unless it's of course just breaching the terms. Then it really depends on the terms of the license.
Yeah. All right. This question comes from Crypto Native. Who is the owner of a digital asset linked to an NFT if multiple people were involved? For example, project founder, partners, artist, or even with the help of AI, if nothing was agreed upon beforehand.
So do you mean the piece of content, or because when you mean digital asset, so when you look at NFT, you have a cryptographic asset.
Yeah, I'm going to say the
content, because it says AI.
The content, the image,
So it probably joint ownership, meaning that everyone has like the entitlement of it. But that's why one of the reasons why you would, if everyone contributed to it, then that's why you would want agreements at the outset. Like that's one of the things, the involvement of AI could potentially interfere with the originality aspect. But because, as we said, the amount of originality that is required for a work to be protectable under copyright is not crazy at the moment.
Huge,
so and I think that like even when the few uses of AI that I've seen within works still had, at least in my opinion, the one that I've seen, a sufficient degree of human involvement to probably be deserving of copyright protection.
Okay, cool. This one comes from Akuti. what do you think about a concept to let users select a license model per token in a one-way direction from more closed to more open? So, for example, the default is commercial rights, but they can go CC0. Yeah.
But so, okay, so normally the project, decides how to govern the intellectual property. So it would be strange for the user to define the kind of use. Also, if you have commercial rights, in a way you can authorize others to use your ape, but you're getting down, like potentially for free, but you're getting down the rabbit hole again on what rights, what happens if you transfer, if you don't transfer, is there a license, is a license in place? It's a bit of a rabbit hole, but
I have an ape. I can't say my ape is now CC0, can I?
Well, you're not the one that really decides whether
it would be Yuga has.
It would be Yuga Lab, but you perhaps could authorize for free someone to make a derivative.
But would that have to be a special agreement that I come to with each individual? I couldn't be like, it's now in public domain, my ape.
A unilateral agreement. I'm not sure. I don't want to say something that is misleading. I'm not sure.
Yeah,
I don't think because you're not the right holder. No, you have a commercial right.
Yeah.
It depends by the terms of the license, so I have to look at that. But I don't believe that would be the case because, again, the IP is actually owned by Yuga Lab, and you have a commercial right subject to certain terms. So for you to open it completely, the implication of that I think would be would go beyond the license.
Yeah. All right. This is from Mr. Roboto. What's the best way to monetize your IP? And what are some unique projects that you've seen that have leveraged their IP?
So again, I mentioned it before. I think Jenkins the Valet is very interesting as a platform. I think that's quite, I like the idea. Well, of course, Pixel Vault, what they've done with, now also legitimately with the Punks comic, they forecast it in advance. But I think those are interesting in terms of how you leverage it. Like, for example, I have a punk, and I've contributed as part of a group of lawyers to the like a guideline on NFTs for the Law Society here in the UK. And I've included, for example, a reference to my punk. It's not really commercializing the IP, but it's there, it's kind of a representation of myself. I guess it depends what you want to do with it. When I bought the CryptoPunk originally, I wanted to inject as much personality as possible into it and have it almost like acting as a brand, as a representation, as an extension of myself. But I guess, if you look at, for example, a lot, I think, on the PFP value would depend either on you as a person, and if you look at G-Money, that is a prime example, but also yourself, Zeneca. Like the way that you leverage it depends a lot. The value of it probably is associated to you as a person. Of course, G-Money has also a punk ape, so the value is already quite good in its own right. But but Adidas would have not entered into an agreement with for a representation of an ape unless for G-Money. I mean, with the orange bean and everything. In terms of other uses, I guess it depends by the industry you're in, right? So it's really difficult. I think, of course, creating some form of media like comic or like some form of animation, toys, I think that can be quite powerful, because you are building a narrative behind the character itself. Whereas, if you just slam it on a T-shirt and expect people to buy it, then I think you would rely more on the traits that particular PFP has. Maybe they're appealing, maybe they have some cultural play. But otherwise, I think that building a narrative is probably one of the most powerful ways to build IP or build value in the IP, because that's really what you're doing.
Yeah. I think I agree a lot as well. I'm seeing more and more both individuals taking their NFT and trying to commercialize it, and just the brands themselves. Like, so much of the power and the value is coming from those who understand that they're building out a story, a universe, a world, storytelling. It's like Taylor's all the time,
well,
basically.
it's the most powerful. I think, like, for example, I was talking about this with Drift, and I think he is an incredible photographer and an even greater storyteller. And I'm not saying that what he says is not it's fake stories. No, it's real stories. But that is extremely powerful. There is a lot of, a lot of value within those shots, also because of the story also because of what he represents, also because of the story that accompanies his work. I think that's very powerful.
Yeah, no, 100% agree. All right, this question comes from OX Compbo. He says, Omri, I was curious what you would recommend for a project that is creator/community focused with respect to IP and copyright for our NFT. And then he adds, I heard, and he's not 100% sure, BAYC owners can't defend their NFTs in court without Yuga legal backing and support, but they can use them at least. Do you have a better approach?
I think that's very interesting and I think that he's making reference to what Ira was saying, which is another lawyer in the space, more experienced than me, I guess. He's in the US, and that was an interesting aspect because as a UK at least lawyer, you don't often think immediately about litigation, because here you have barristers and solicitors tend to focus on the commercial side and barrister in court case. But yeah, I think it's very interesting. It depends on the terms of the license. In terms of, some licenses, especially between companies, can give the licensee, so the person that receives the license, the ability to defend the case in court. But based on, the lack of addressing in the license that Yuga Lab provided, then that would likely be the case. It would be for the brand, for the IP owner to defend it, which is why, for example, going back to the CC0, you wouldn't be able as a commercial licensee to decide, to waive or to seize, basically, to waive the right, the intellectual property right over your asset. You could perhaps start licensing it for free, to so many people, so to have almost an equivalent effect if you want, but you wouldn't be able to just declare it. I don't think you would be able to declare it as a CC0. It's not the right that belongs to you.
All right, I think we have two more questions. This one is similar to the previous one, actually. How can someone, or the one before that, how can someone go about utilizing their IP? Where would you offer the service? Or is it more likely that someone would approach you if you own the NFT they would like to use? If that's the case, how can you verify their intent is genuine?
Well,
that comes down to human nature.
Exactly,
stuff,
I was about to say human nature, and normally what happens in the commercial world, you would try to mitigate risk by running due diligence in the particular entity that is seeking IP from you. Looking at their history, looking at who they are, what they say, their operation, and then you would also mitigate the risk commercially through the agreement, because you would try to seek as much comfort as possible. But when it comes down to these type of uses, it's hard to say. I think it can go both ways. If you go on a platform like, again, Jenkins, or a platform that allows you to make your PFP available for others to commercial leverage, then in that case, of course, it's the first instance you're seeking for someone to get the license. In other cases, I've heard, particularly if you have PFPs that are associated with high value traits, for example, let's say a Bored Ape that has the golden, the hip hop vest. What's the name of the trait? The golden,
I'm bad with traits. I know what you're talking about there.
Yeah. So maybe you might have a PFP that is particularly suitable for a product, and so they want that particular one, and that puts you in a good commercial position in terms of negotiating something that is favorable to you. So.
Yeah. I'm mindful of time. Do you have to jump off in a couple minutes, or?
In a couple of minutes I have to go.
Okay. Let's wrap it up then. I think that we basically got to all the questions. Thank you so much. This was really, really insightful. I would love to get you back. Just honestly, I think, and the feedback that I'm seeing, people are really enjoying this as well. And
thank you.
Really, thank you. Thank you.
Thank you for having me here again. And just to remind, this is no legal advice. Don't think I gave any advice, but be mindful of that. Just take. I think law and regulation should be part of the design process now, and especially in this industry. And I come from as I mentioned at the beginning of the podcast, I come from the creative industry. I used to be an audio engineer, and one thing I've realized: sometimes limitation really do spark creativity. And I'm not saying I'm not trying to say, become aware of limitations so that then you can go and become this amazing tax evader. That's not what I'm saying. I'm saying
you heard it here first.
I'm saying, be aware of these limitations and then factor them into the way that you design your particular project. And I think being compliant by design can also be very valuable to a project and very appealing for collectors.
No, you made a lot of good points, and I think have given a lot of people a lot to think about. So thank you so much, and thank you everyone for asking questions and for tuning in. And
thank you.
Catch you next
so
time.
much.
All right.
Have a good evening.
Bye.